Thanks, Pat. Good day, everyone, and welcome to today's Docket, Reliance Matrix's quarterly series highlighting key developments in the absence space. I'm Nell Walker, Reliance Matrix's Vice President of Product Compliance, and I'm pleased you could join us for this quarter's live Docket presentation. We've got a great agenda and panel for you today. First up, Shelby Felton, our PFML expert, will update us on what's happening in the world of state-paid family and medical leave, walking us through important legal and regulatory updates and developments there. Following Shelby, Lana Ruprecht, our product compliance expert, will show us again why she's a multi-pronged talent by sharing legislative updates, highlighting the latest regulatory guidance, and discussing recent regulatory enforcement and litigation actions to be aware of. Finally, rounding off our panel's topics today, Marty Carty, Reliance's Leave Guru Emeritus, will walk us through our quarterly compliance lesson. What to do if you have suspiciously similar leaves across different employees. Finally, time permitting, we'll wrap up with some Q&A. And with that, let's jump into our program. Shelby, would you take us away?
Thanks, Nell. Happy to. We're going to talk about our PFML updates today. I first always want to introduce everybody to our statutory disability and paid family leave law map. This is the map that you can click on each state, and it will provide you with the particulars for each state's PFML program, from who is an employer to a covered individual, contribution rates, benefit calculations, and any private plan application processes. I also want to remind everyone each time about our other legislative tracking map. We use a legislative tracking system on this next map to advise our clients. Every day we track when new PFML legislation is introduced and how it travels through the legislature. For example, we just got notice today that the District of Columbia passed a resolution whereby statutory offsets cannot be made against DC's Universal Paid Leave Program. The STD offset prohibition has actually been in place for quite some time. What's different with this resolution is that there's now no distinction based on the situs state of the STD policy. We'll look forward to more information on that one coming up, since we just received word about the resolution yesterday. So for my presentation today, I'm going to be taking you through the PFML coming attractions. Here we have a list of all of our states that are coming up and their opening dates. I'm going to walk through trailers of each of these states, but I want to point out quickly Vermont. Vermont is remember, completely voluntary state, and its program will be phased in over the next 3 years. Phase 1 is going to provide benefits to state employees beginning July 1st of 23, so it just started. Phase 2 will go into effect in July of 24 and expand to employers with more than 2 employees. And then phase 3 in July of 25 will be to those employers who do not offer Vermont family leave insurance, self-employed Vermonters, and any employers with just 1 employee. So we have a lot of PFML trailers to show for this quarter. So let's look at Minnesota. All of the information on this slide you can find on that stat plan map microsite page I showed you. But let's talk a bit here about some of the particulars for Minnesota. We see eligibility requirements in a lot of states. In Minnesota, they're looking at 5.3% of the state's average annual wage. What I want to point out with Minnesota, though, is that they add on over a base period. And Minnesota has developed quite a complicated definition of base period. So we're going to be looking and crossing our fingers for regulations that'll help us better define that base period. For eligibility, independent contractors and self-employed individuals can opt into the program. One other eligibility issue I want to flag is seasonal employees. Minnesota has a very interesting definition of seasonal employee. It's someone employed for no more than 150 days during any consecutive 52-week period in the hospitality industry and only by specifically qualified employers. So those kinds of seasonal employees are excluded. The amount of leave that Minnesota is providing isn't unusual. I want to point out intermittent leave, however, could be different. Minnesota has thrown in that employers can limit intermittent leave to 12 of the total 20 weeks that are being offered. Also, family member. What we're seeing in the trend, and Minnesota is following that, is a family member beyond a blood relation. And here we've got someone that has an expectation or a reliance that the employee would care for them. Job protection is being provided in Minnesota. What we look for a lot of times is how many days do you have to be employed first, if any, and in Minnesota, it's 90. If we move to the next scene of Minnesota's trailer, we will see information about benefits and contributions. So Minnesota has what we see pretty consistently, a tiered benefit amount with a minimum and a maximum. But again, it goes back to that base period, and Minnesota's definition of base period takes up about a page. They also have an interesting definition for average typical work week and high quarter. So we're going to be looking to regulations to help us out with those benefit calculations. Contributions, we're not surprised at all to see a 50-50 contribution. What's interesting about Minnesota is that they put in their statute that contribution is subject to change. So we'll be watching for that as well. There are different premium contributions for employers with fewer than 30 employees. Again, we see the trend of setting a cap for contribution rates and also for capping the amount of wages subject to contribution based on the Social Security wage base. Another interesting part of Minnesota is this employer contribution rate. Minnesota has split out 3 different contribution rates depending on whether you are participating in the state plan for either the family part of the benefits or the medical part of the benefits. So that's going to be something that we're going to have to work out again when we hopefully see some regulations in the coming year. Now let's watch the Maine trailer. Barely mentioned Maine last quarter. And then Tuesday, July 11th, the governor signs the budget bill, which included the PFML funding. So now we have a complete trailer to show you for what Maine's going to be offering. Now, this information's not on the stat plan's website yet. That'll be coming. Contributions, again, not too surprising for our dates. And our leave reasons are fairly typical. How much leave they're providing, I would say, is a little on the low end with just 12 weeks. Again, look at that family member trend. We're finding someone who's not related by blood. And the interesting thing about Maine is that they have included that word designated, a designated individual. So we're going to be looking for regulations to find out what that designation means. We have our job protection. Notice it's different than Minnesota. We have 120 days of employment before you're entitled to job protection in Maine. If we look at Maine's next scene, we have our usual typical tiered benefit calculation. In Maine, employer contributions are limited to employers with 15 or more employees. Now, that doesn't mean that employees at companies with less than 15 aren't entitled to benefits. It just means that there won't be an employer contribution. Again, we see our same contribution caps. and the wages at the Social Security limit. One thing we're going to be waiting for from Maine, though, we don't know what the contribution rate will be. So that we expect to see coming in the next year as they work on regulations. Our next trailer is for Maryland. Now, I talked about Maryland last time, but remember, they recently rolled up the red carpet and delayed their opening by a year. This slide information is on the Stat Plan's microsite. So what's Maryland doing? Why am I even talking about them? Because they're working on their regulations. They've been holding a series of public meetings, which you have to register for. But what we've seen so far is an outline for regulations regarding private plans. And we've seen discussion points for self-employed persons opting into the program. On July 20th, Maryland is going to be talking about discussion points for regulations regarding contributions. Now, what we're hearing from industry experts is that although there are these meetings going on about regulations, there's going to be some statutory cleanup next session. So we may not actually see a whole lot of regulations drafted before the end of the year. Now let's look at the trailer for Delaware. Delaware might seem like a second run movie rather than a coming attraction since it was signed over a year ago. However, it is now having its second act in regulations. So the slide you see here is what we know from the statute, and it's included, all the information is included on the stat plan. I do want to point out, I'm not sure what the Rotten Tomatoes review is going to be for Delaware, looking at their complicated contribution rate structure that you see here. Also, they're at the low end of how much leave is being granted. You see there for parental leave, we've got 12 weeks, and for medical and family caregiving, we've got 6 weeks in a 24-month period. They are looking more towards the FMLA for their eligibility requirements. So if we look at the next scene for Delaware's trailer, they've added, these are the regulations that they have posted, and those were just posted this month. So this is their second act. Now you can see here that they've provided for more localization information. So we've got 60% of the work hours being in Delaware each quarter. What they've also said, though, is that employees outside of that 60% can be reclassified as employees based on an agreement between the employer and the employee. What we don't know is what does it mean to be reclassified and how is that done? Similar to Connecticut, Delaware in their regulations has offered a tracking method where employers can choose which method to use, whereas most other states we find are using a measure forward tracking system. You see there the opt-out dates for private plans. So employers have to decide between September and December of 2024 whether or not they're going to opt out of the state plan and have a private plan. One interesting thing we have not seen for private plans in other states. Self-insured groups in Delaware have to have at least 100 covered individuals in the plan at all times. We also have this interesting one you see here on the bottom. Employer paid time off benefits that are already in place and were in place as of May 10th, 2022. Excuse me. If the plan is deemed comparable, that plan can continue until 2029. What we don't know is how is that plan going to be deemed comparable? What sort of benefits need to be in place? So those are the Delaware regulations. Let's look at the trailer for Oregon. Oregon is constantly in the PFML theater. It reminds me of the Fast and the Furious sequels or Mission Impossible, both of which might actually aptly describe Oregon PFML right now. Delay. Is the program going to be delayed? That's the big question for everyone. And we understand from the state that we're going to find out next week. So watch for a blog post letting you know whether or not Oregon's going to be rolling up its red carpet. Right now, the state is telling us that you can still apply for benefits beginning August 14th. Senate Bill 999, we mentioned last time, that provides for an alignment between OFLA and Oregon PFML. Lana's going to take us through all the details of that later. I want to talk about Senate Bill 913, which we're still waiting for a signature, but what we understand is that the signature deadline is August 4th, and if it doesn't get signed, it'll become effective September 24th, regardless of signature. So this provides some significant changes. The max contribution in Oregon was capped at $132,900. But with Senate Bill 913, the maximum contribution is going to be based on the Social Security wage limits, like other states do. Senate Bill 913 also allows the department to share information with claimants and employers if it's necessary for benefit payments and collection of contributions. So that's going to help us with the collaboration of benefits, so between different benefit types. Another very interesting point, the regs deleted language limiting benefit payments to 100% of the employee's average weekly wage. It's going to be possible for employers now to permit employees to use sick time, vacation, and other paid leave to earn over 100% of the average weekly wage. We didn't understand why the state eliminated this language. What they told us is that an employee's average weekly wage is the total wages earned during the first 4 of the last 5 quarters, and you divide that by 12. That's how you get the employee's average weekly wage. But what if an employee only works half a year? That could be really low. What Oregon heard from employers was that they didn't care if employees supplemented with accrued leave to increase their weekly benefit amount. Now looking to Oregon's next scene. Last time we talked about rules. We also talked about an increase to the state average weekly wage, which we see from a lot of states in July or January or July. We talked last time about the Batch 7 rule amendments. The public hearings were held in June, and those rules will be finalized in August. And now we have another Oregon sequel in the Batch 8 rule amendments. Yes, 8 sequels. So these rules cover the topics I have listed there. The ones I want to point out are it changes the definition of affinity as it relates to family relationship and provides some factors like shared personal responsibility, financial responsibility, or do you use that person as your emergency contact? Do you cohabitate with that person? It's also got some new provisions for job protection, that you have to be placed back into a position within a 50-mile radius. And if you can't be placed back into your original site location, you have to be placed back into a location that is closest to your former job site. There are also a number of new rules here dealing with confidentiality. Now, these rules have been proposed as temporary rules. And the reason is that they need to have them in place before the go live date, the hopeful go live date in September. So what's going to happen is those rules, when posted, will be valid for 180 days starting in August. Then after that, there will be public hearings before the final rules are done in January of 2024. So will that be the end of it? Nope. They're already telling us about the Batch 9 rule amendments that will be coming this fall. So now let's look at the trailer for Colorado. All of this information is on our Stat Plans website. Colorado is also challenging Harry Potter and Lord of the Rings for the number of sequels. As we talked about last time, they had 3 new sets of rules that were effective or will be effective here in a couple of days. They've now posted rule changes for Rule 1107-1 and 1107-2, which is local government participation. 1107-1 has things like some changes to definitions, some changes to employer size, and when you're on leave, you're still considered an employee when you're on USERRA leave. But let's talk about Washington's trailer. Washington is unfortunately still dealing with production problems like any over-budget movie. So what they're doing is they have changed their contribution rates, and they're hoping that these changes will solve for the solvency problems that Washington has had since the beginning. We've also seen some new regulations for asking for the state for information, which you can see here, like types of leave, duration, and approved dates. Now let's talk about New York. New York is like a Turner Classic movie. It's been around for a long time, but it has some new rule changes. You can see here that they've added organ donation, and they now have a presumption of disability for pregnancy. That presumption starts 4 weeks prior to the estimated due date, 6 weeks after a vaginal delivery, or 8 weeks after a cesarean. They've also provided some new information regarding denying claims and claim rejections. And now employees can submit benefits by phone or request benefits by phone. But let's look at our last and final trailer. This is the expansion of the new genre of family leave. Family leave insurance is a class of insurance that can be offered. Here we have all of the states that are offering or going to be offering this class of insurance. Typically, benefits can be written as an amendment or a rider to a group disability income policy, included in a group disability income policy, or it can be written as a completely separate policy. Similar to PFML, it can offer paid leave benefits for leave due to birth, placement, bonding. It can be offered for care of a family member with a serious health condition or military exigencies. These types of insurance don't typically offer a direction, so you don't have any required direction for the duration of benefits, the percentages of wage loss, or which family members are covered. So that's all of our PFML coming attractions. And now Lana is going to provide us with our legislative and regulatory update.
Thank you, Shelby, for the very thorough PFMLA update. It was really helpful. Next, we'll turn to just the non-PFML legislative update. And I'll cover, like I said, any non-PFML legislative activity that we've seen this past quarter. So first, we just want to remind everyone that the Pregnant Workers Fairness Act is now in effect. We've updated you on the last 2 quarterly compliance updates that this was coming. It became effective June 27th. The EEOC will start accepting charges under the PWFA on beginning June 27th, but the situation complained of in the charge must have happened on or after June 27th in order to be covered by the Act. Now, that's not to say there could be a claim under Title VII, the PDA, or the ADA that happened before June 27th. But if it's a PWFA claim, it has to have happened on or after June 27th. So just a reminder, the PWFA is a federal law that requires employers to provide reasonable accommodations to a worker's known limitations relating to pregnancy, childbirth, or related medical conditions. So it also covers post-pregnancy as well, unless the accommodation will cause an undue hardship. So as a reminder, this applies only to accommodations. It does not replace any state or local pregnancy accommodation laws that could be more protective or more generous. One new update on this that we didn't cover before is there is an updated poster that has been posted by the EEOC, and there's a link to this here on this slide. Employers can put this up. And just if you haven't put it up yet, that's okay. Get it up as soon as you can. The website, the EEOC actually said, do not put the poster up before June 27th because there shouldn't be any confusion. So next, there are some state leave laws that we want to update you on, and their legislative update. First, we have Nevada. They already had a domestic violence leave law that was recently amended to include not just victims of domestic violence, but victims of sexual assault. And this change is effective January 1st, 2024. Next slide, we have the Minnesota legislature. It's been very busy. Shelby covered the PFML update, and I provided a link to a blog post that we wrote recently that outlined the PFML update, the PFMLA law, as well as additional legislative changes. One change I want to talk about is Minnesota amended its pregnancy accommodations law so that it now applies to all employers, not just employers with 15 or more employees. It also, in its pregnancy accommodation law, provides more examples of what is considered a reasonable accommodation under the law. Now, again, these are just examples. This isn't like an all-inclusive list by any means, but they did add more frequent or longer breaks as an example, temporary leaves of absence, modification in work schedule or job assignments, and more frequent or longer restroom, food, and water breaks. So again, the law already included examples such as a temporary transfer to a less strenuous or hazardous position, seating, and limits on heavy lifting. Those are all still there, and these are just additional examples. One important aspect of this law that I want to point out as well is this law eliminated the undue hardship defense for employers if an employee asks for more frequent restroom, food, or water breaks as an accommodation. So that means if you have employees in Minnesota and they say this is an accommodation they need related to their pregnancy, you cannot claim undue hardship. And so this is an example back when I was talking about the Pregnant Workers Fairness Act, how some laws can be more generous, and the Pregnant Workers Fairness Act does not preempt or change that. This is an example of a more generous provision with the not allowing the undue hardship defense. So the changes to the pregnancy accommodation law in Minnesota actually were effective July 1st. So if you haven't already, make sure your policies, notices, and everything are updated and changed. Next, Minnesota also, effective July 1st, we're still on the Minnesota slides, amended its pregnancy parental leave law, which provides 12 weeks of unpaid leave so that all employers are covered. Previously, there needed to be 21 or more employees, and now it applies to all employers. And also, employees are covered from day one of employment. There's no longer a requirement that employees be 12 months length of service requirement or a certain amount of average hours worked. Again, these went into effect July 1st. Now, I don't have it on this slide, but it is covered in our blog post. Minnesota did enact a law that will be effective January 1st, 2024, that requires employees to accrue safe and sick time. This isn't the type of leave law we administer, but we've been receiving quite a bit of questions about it. More about that is in our blog post, but basically employees can accrue 1 hour of sick and safe time for every 30 hours worked, capped at 48 hours per year. And this covers sick time, domestic violence, leave associated with victims of domestic violence. It also covers time off related to health concerns for illness associated with a public emergency and closures due to weather or a public emergency. So next we have the amendments to the Oregon Family Leave Act. Shelby mentioned I'd be covering this. This is really great, a great start with OFLA making amendments to its act in order to align with Paid Leave Oregon. First, effective September 3rd, 2023, the definition of the covered family member will be revised to align with Paid Leave Oregon, and the details of how that's defined are in the slide. Previously, OFLA limited this to an employee's spouse, parent, child, parent-in-law, and in loco parentis. So it's been expanded so the definition matches up with the Paid Leave Oregon definition. Also, OFLA, under the new amendments, OFLA, the FMLA, and Paid Leave Oregon will run concurrently instead of stacking them, which again, that's good news for employers and a welcome amendment that we're seeing. The amendments also state that beginning July 1st, 2024, the benefit year calculation will mirror that of Paid Leave Oregon. So it will change to the 12-month benefit year beginning the Sunday before the employee first takes leave. Right now, OFLA has the 3 different methods to calculate similar to the FMLA. So that will change. I think it's important to note that employers do not have a choice about this change, but they can choose to change their current OFLA calculation now to the 12-month benefit year that matches up with Paid Leave Oregon if they wish. Finally, the new OFLA law makes clear that employers must continue to make regular contributions to the cost of health insurance premiums while employees are out on leave. It also provides that if an equivalent position is not available at the original job site, then another position should be offered if there's one available within 50 miles. Currently, OFLA says within 20 miles. And again, these are just changes that are made to line up with Paid Leave Oregon. So next, we have the Virginia Organ Donor Act. This is another update that became effective July 1st. This requires that employers with 50 or more employees must provide 60 business days of leave for organ donation and 30 business days of leave for bone marrow donation. The Act provides job protection. It cannot run concurrently with the FMLA, and violations result in fines beginning $1,000 for the first violation and up to $5,000 for additional violations. There's more information and links in this slide for your information as well. And then finally, for a legislative update, there's a couple of pending amendments in Illinois that are pending before the governor, and we're watching these. One is a Blood Donation Leave Act, giving employees up to 10 days of leave to serve as an organ donor. The other is the Child Extended Bereavement Act, which permits 6 to 12 months of leave depending on the size of the employer. So that's it for the legislative updates. Now let's take you through some regulatory updates, which there's a couple of interesting DOL opinion letter and also a notice that we want to talk about. But first, on May 30th, the Department of Labor issued an opinion letter. If you don't mind going back 2 slides, Pat, issued an opinion letter on May 30th, 2023. And this opinion letter just solidifies what's already provided in its regulations. And I think it's just the slide right past that we have more information on this. But basically, the FMLA regulations have already provided this, but this opinion letter, which is very detailed, and if you are a FMLA nerd, you'll find this very helpful. But if it says if the employee is using a full week of FMLA that happens to contain a holiday, then there's no impact. So if we just had the 4th of July holiday last week, if you were taking that entire week off as an employee, then that would not be counted against your FMLA leave entitlement. It would not make any difference. But if an employee takes just part of the week off for FMLA, the holiday would not be counted against the FMLA leave entitlement unless the employee was already required to work on that holiday. So our slide provides links to a blog post we wrote on this. It also provides links to the opinion letter itself. So go ahead and review that for your reference. Again, I found the opinion letter very helpful, but like I said, it doesn't really change what the regulations already said. Next, the Department of Labor updated its FMLA poster. Substantively, there are not any regulatory or statutory changes. In fact, the DOL says, prior posters are still in compliance. But here in our slide, that's just back one, there is a link to the new poster along with a link to the blog. And next we'll go to the COVID-19 Technical Assistance Manual that was updated May 15th, 2023. Key updates to this is basically the EEOC is saying if an accommodation was granted during the pandemic, that doesn't need to end, but can be reevaluated. And then there's additional examples of long COVID as to what a reasonable accommodation relating to long COVID is in the slide. You can see that there. And we provided a link to the manual here. So next, let's go to the enforcement and litigation update and discuss some enforcement actions. First, we had the Department of Labor had quite a few interesting enforcement actions involving the FMLA. We don't always see these. We often see the DOL as more FLSA enforcement actions. The first one on this slide is we have a yard engineer who is terminated after he returned from FMLA because he didn't pass a fit for duty test. Now, the FMLA, as many of you know, does allow employees to, after they're on leave, they may need to require or pass a fit for duty test before they can return to work. But the Department of the FMLA regulations require that they receive notice beforehand. So the first problem here, according to the Department of Labor, is this employee was not notified that a fit for duty would be necessary. And then the information obtained in the fit for duty was used to retroactively reject his employment application from 8 years ago. So that's the second problem. So these bad facts put the employer in a difficult position, and you can see there are back wages owed and negative publicity. The other case from the Department or enforcement action from the Department of Labor is Wicked Taco. And just the name of the employer, right, sounds appropriate given these facts that the Department of Labor put out in its news release. There was an employee who was hospitalized, released to return to work a few days later. The day he was released from the hospital, he walked into the place of work, gave him the doctor's note that said he had until May 4th until he could return to work. And the employer disregarded the note and actually said, you have to come back to work right now. So we made him work that day the day he was released from the hospital, and then later terminated him for unexcused absences. So again, this is not a good set of facts for this employer, and it resulted in some back wages. And then finally, we have U.S. Logistics Solutions, where an employee requested FMLA to care for a spouse after giving birth and bonding leave, was not only denied this, but during a discussion, same conversation where he's discussing his leave, this person was then terminated for payroll theft. I'm sure the employer has their side of the story, but again, these facts do not look good. The Department of Labor was not impressed with these facts, and there's not only the damages listed here, but also the press release. I have to read you how it started out because it's damaging for the employer. It says, the Department of Labor wrote, a Covington distribution center turned an employee and their family's joyous celebration of life and a chance to bond with their newborn into a nightmare by illegally terminating the worker for exercising their rights under the Federal Family and Medical Leave Act, an investigation has found. So no one wants publicity like that. So train your supervisors, train your managers, train your HR going forward. So that's it for the Department of Labor enforcement. Next, we have EEOC settlements. And there was quite a huge number of EEOC settlements and lawsuits this last quarter. I'm just pointing out three significant ones. And there's links to each of them in this slide. And I want to point out, too, a common theme in all of these settlements and often in these lawsuits is the EEOC does not like to see when employers have bright line rules with no flexibility. And also the EEOC does not like to see a failure to conduct a fact-specific assessment, right? So again, I know we've covered this in prior quarterly updates, but you really need to look at everything on a case-by-case basis, even if there's a time when you cannot accommodate and you know there's going to be undue hardship, go through the process and really look at everything and document it. Again, bright line rules and failure to conduct a fact-specific assessment just gets you in trouble with the EEOC and ultimately if you're in court as well. So I'll run through these quickly. First, we have Sanderson Farms. Here, an employee was allegedly sent home and fired after he complained about migraines and cluster headaches. There was no discussion or assessment to determine if there could be an accommodation. Similarly, in the next case, Conduit State and Local Solutions, an employee was told if you can't hear, you can't do your job, was fired. No assessment, no discussion, no interactive process. And you can see these cases have not just damages, but consent decrees. And we've talked about consent decrees, which is oversight by the EEOC for a period of time on training, policies, future data that the EEOC needs to see. So in addition to negative publicity damages, the oversight by the EEOC is not something as an employer you want. And then this final case, this is a high damages case as well, or settlement. It says on the pregnancy discrimination case, all employees who were pregnant were required to tell the company and get a doctor's note releasing them to work without restrictions. The lawsuit also alleged that pregnant employees were denied reasonable accommodation, but non-pregnant employees were not. So this was brought as under the PDA Title VII. But I want to point out this is an example of the type of cases that would also may be actionable in the future under the Pregnancy Workers Fairness Act. So next, let's turn to some key litigation. These slides have a lot of cases listed on them, but I'm just going to cover the key ones. The first one is a very important decision we all need to know about, a U.S. Supreme Court case, Groff versus DeJoy. This case, the U.S. Supreme Court actually redefined and clarified the standard employers must use when they're evaluating undue hardship under Title VII when an employee requests a religious accommodation. This is very important. So for nearly 50 years, the courts have defined, and the EEOC has defined undue hardship under Title VII when an employee makes a request for religious accommodation pretty low. It was more than a de minimis cost. This case clarified that standard, said, no, that's not the proper standard. It should be substantial in the overall context of an employer's business. So this is significant for employers when they're dealing with an employee requesting a religious accommodation. Now, this standard's still lower than the ADA and also the PWFA undue hardship standard, which is significant difficulty or expense, but this is a higher standard than the de minimis costs. This case, quickly, I'll tell you, involved a postal worker who could not work on Sundays. And the employee, initially it wasn't a problem, but then when the U.S. Post Office entered into a contract with Amazon, the employee was required to work on Sundays. The employer, I read the lower court opinions up to the Supreme Court. The employer actually worked quite a bit with this employee, but ultimately they just had difficulty with scheduling. There was a collective bargaining agreement and the ability to have it so the employee was never working on Sundays. And using this new standard of substantial in the overall context of employer's business, the court may determine that they're still, it meets that standard. But the Supreme Court said this needs to go back down to the lower court to determine if using the new clarified standard. So next we have several FMLA cases. The most interesting one, Marty is going to cover at our quarterly compliance update, so I'll turn that to her. The other ones you can check out for yourself because I want to make sure there's time for Marty to talk about the Adkins case. But I do want to point out that, in the Clark case, that's on this slide, we added this case because it outlines the fact that under the FMLA, a supervisor can be individually liable if there's sufficient control over the employees. I think a lot of employers don't remember that. And so again, just want to emphasize how important it is to train your supervisors, make sure they send people to HR and be able to issue spot FMLA issues. Next, we have a few interesting pregnancy-related cases. Again, I'll just cover those of interest quickly. I do want to mention Barton versus Warren County. This involved claims brought by a correctional sergeant against her employer for discrimination and retaliation under Title VII and the PDA. What was interesting in this opinion is that the court, this was a very fact-specific opinion. There was a lot of facts in it. But one thing that really caught my attention was the court looked at the employer's policies and said that when if a woman was a correctional officer and was pregnant, she either needed to, under the policies, resign, remain in full duty status regardless of her condition, or use sick or unpaid leave. So the court said, even if it's true that all employees are treated this way, this policy is sufficient evidence that the county imposed a significant burden on pregnant workers without non-discriminatory reasons sufficiently strong to justify it. And then the court actually looked and quoted in a footnote the Pregnancy Workers Fairness Act, saying, due to recent legislation, in the future, this type of policy would be prohibited under future legislation. So again, I want to point that out. Courts, EEOC, they are looking at this Pregnancy Workers Fairness Act. So for future violations after June 27th, you really want to be buttoned up as an employer and make sure you're working with employees case by case, making exceptions to policies when there's pregnant worker involved. And also when there's, any kind of reasonable accommodation requested. Get back to that theme, no bright line rules, no look at everything on a case by case basis. There are several notable ADA cases over this quarter that you can look at in your, when you have time. They're all cited here, but I want to make sure Marty has sufficient time. So I'm going to turn the next part, the quarterly compliance lesson, over to Marty right now.
Thanks, Lana, and welcome everybody. I'm really happy to join you. I always have fun doing these quarterly compliance lessons. And in particular, this time our lesson is based on a case out of the Fourth Circuit Court of Appeals, Adkins versus CSX, and this was just decided on June 16th. So it's fairly hot off the presses, and it's kind of a fun case to talk about and a lot to learn about. The issue here that we're addressing today is, what do you do when multiple employees file suspiciously similar FMLA leave requests? And at the bottom of this slide are a couple of links for you. One is to the Adkins court opinion itself, in case you want to read that. And the other is to our blog, which will have lots more details than we'll go over here today. I'm going to hit the high points, but there's the blog will take you through everything if you need some more details. So on to the facts. CSX is a transport company with various work sites, and in 2017, it issued notices of upcoming furloughs at its Huntington Beach facility in West Virginia. Under CSX's benefits plans, employees on medical leave when furloughed would receive health and welfare benefits for up to 2 years from their date of furlough, but employees not on medical leave on the date of furlough only receive 4 months of continuing benefits. So lo and behold, in the few weeks after the notices of furlough went out, 67 employees at the Huntington facility filed FMLA claims, all alleging soft tissue injuries, all off duty except one employee, which means there would have been no workers' comp claim, no workers' comp record of it. All 67 employees' injuries, soft tissue injuries, were certified by one of 2 different chiropractors, no other providers involved. All of them requested continuous leave off for 8 weeks or more. 8 weeks was a really dominant theme. The CSX medical officer suspected fraud. Pat, you can go on to the next slide here. And the reasons that the medical officer suspected fraud included all those facts I just recited, but he'd never seen so many claims in close proximity. In fact, he received 14 claims, 14 certifications from one chiropractor in one day. And the medical forms were similar in content. They described generalized minor conditions such as sprains or muscle spasms, but no individualized assessment on any of the 67 certs. And in the medical officer's opinion, these types of injuries should take only a few days to heal, not 8+ weeks. So the medical officer reported his suspicions to CSX's Labor Relations Department. That's the term used in the case. I think my reading is that their Labor Relations Department is what we would consider more commonly the human resources. And pursuant to the collective bargaining agreement process, CSX gave notice to each employee and held a separate hearing for every single employee. And at the hearing, the employees had the opportunity to provide additional evidence to support their leave request and to cross-examine CSX's witnesses, but not a single employee took advantage of those opportunities at their hearings. After the hearings were over, they were recorded, they were transcribed and recorded and transcribed. And one of the CSX vice presidents reviewed all of the transcripts, and together with the Labor Relations Department, they considered all the evidence and decided to terminate 67 of the employees. On appeal, internal appeal process, most of those were upheld. There were a small number that were reinstated to employment. We are not told the facts as to what made the difference. So as a result, then, surprise, 58 employees sued CSX for FMLA interference. Several other claims as well, but we're just going to focus on that one here. The trial court upheld the CSX's terminations, and that was affirmed by the Fourth Circuit last month. And in a nutshell, again, you can read more about this in our blog post. The suspected fraud was not a pretext for some other illegal reasons. It's not something that CSX made up to hide a true motive, such as retaliation for taking FMLA leave. And the second argument that CSX had, or that the employees had made, was that CSX couldn't terminate them until it had followed several other FMLA procedures, like second and third opinions or recertifications. And the court said the evidence, it was so very clear that CSX's suspicions were well-founded, and that those other procedures under the FMLA that the employees said CSX should have followed were optional and not mandatory. They had plenty of grounds to go forward with their termination. So what lessons do we learn from CSX? They did some things right here that, whether you're unionized or not, you can follow and learn these lessons. And the first one is that they provided the employees the opportunity to explain their why they need the leave and to present more information. Even if you don't have that formal hearing process that the company here used, you can make sure you talk to the employee and get their side of the story, give them a chance to explain. There sometimes will be a legitimate explanation for what's going on. CSX also used more than a single decision maker. The vice president, after reviewing all the evidence together with the Labor Relations Department, made the joint decision to terminate these 67 employees. So that was a good safeguard to protect against a single decision maker being accused of improper motives or whatever. And then the third thing that CSX did that was good was they let the employees go ahead and take the requested leave during the investigation. And the reason that that's an important lesson is because sometimes you will investigate and you'll find out that no, the employee really does have a need for that FMLA leave. If you have denied them the leave in the meantime, that could be construed as FMLA interference and give the employee another claim. So do go ahead and always consult your employment attorney before you take any negative actions against employees in situations like this. But here's what else I like about this case is that it gives us an opportunity to talk about other things that employers could do beyond what CSX did to help control this situation. And my recommendation is to go ahead and act on, even if you just have two suspiciously similar leave requests, especially with a certification from the same provider. It's no coincidence in this case that so many employees went to the same two chiropractors and got nearly identical FMLA certs. Word spreads in the workplace. And so even if you catch it when you start seeing a trend, and word will spread that you're taking a look at these leaves and not just granting them on the face of the certification if there's reason to question it. Second lesson, or second consideration here, is think about whether there are any obvious motives for multiple employees to be submitting these similar leave requests. In this case, it was extended benefits. It was quite obvious to CSX what the motive could have been. There can be other motives as well. For example, that employees might act on. For example, seeking intermittent leave to avoid mandatory overtime. We see this among our client employers periodically, where all of a sudden there's a rash of employees who come in with medical certs saying they can't work more than 8 hours a day or 40 hours a week or whatever their scheduling issue might be. So when you see have a motive like that, that can support further inquiry. Next pointer, review the certifications carefully when you receive them to make sure you've got all the information you're entitled to. This is true always, but especially when you're seeing a rash of similar certs like this. A doctor who just fills out a form with what the employee asks for or wants is unlikely to provide much detail or specificity. And yes, that can happen. And the provider is not necessarily intending to provide false information. Well, 67 certs between 2 chiropractors might lead to a different conclusion in this case. But it's more likely that the providers just don't really understand the FMLA and how this affects employers, and they just give their patient what they want. Do go ahead and consider requiring second or third opinions. That would have been clearly expensive for 67 cases for CSX, but on a smaller case, even though there is an expense involved, it can be well worth it. Again, word spreads throughout the workforce that you are looking carefully at certifications when there's something questionable coming up, like certs from the same provider or asking for the same relief among several employees. So do consider those second opinions. And then my last tip and my favorite one is beware of the chiropractor certification. The root of the problem in this case was that there were just 2 chiropractors, nobody else certifying soft tissue injuries off the job for all these 67 employees. Now, I don't pretend to understand what a chiropractor does or doesn't do, and I know a lot of people swear by them, but the FMLA regulations are very specific that an employer has to accept a certification under the FMLA from a chiropractor only when, and I'm going to read this because I don't have it memorized, only when the FMLA request is for treatment consisting of manual manipulation of the spine to correct a subluxation as demonstrated by an X-ray to exist. Now, subluxation just means the spine is crooked to one degree or another, and chiropractor manipulation can help that, I understand. But if you get a cert from a chiropractor, make sure to see what the condition is, because you don't have to accept it unless it's for subluxation of the spine. Make sure there's an X-ray. You don't want to ask for the X-ray. I mean, what would you do with it after all? But make sure that the chiropractor says, yes, this is supported by an X-ray. And so in the CSX case, for FMLA purposes, they could have rejected all of these certifications on FMLA grounds. They had other considerations playing into it, but in your case, perhaps that will help you. And that doesn't mean deny the employee's leave, but it means go ahead and give them a chance, reject that cert and give them a chance to get a cert from an appropriate provider. So thank you very much, Pat. I'm going to turn it back over to you.
Thanks, Marty. Before you go away, we did have one question that came in right at the end of your session there. Is the medical provider under any legal obligation to, complete paperwork on behalf of the employee?
A medical provider is not, and that's one of my grievances about the FMLA, is that it imposes no obligations on the provider. So a provider can refuse to do it, or they can do it fairly lightheartedly, and there are no consequences to the provider.
Okay, thank you.
Mhm.
We did have another one come in, Shelby, if you're available to jump in here. When you were covering some of the new provisions that are going to become effective in New York, was there an effective date for any or all of them, or are they immediate?
No, those don't become effective until January 1st of 2024. Good question. I should have covered that.
Thank you. Finally, for Lana, I apologize, I lost it. What do employers do when they suspect employee performance issues are a result of language barriers?
Well, that's a good question. I'm not sure I understand it. I'm not sure. Is there any
question itself came
clarification or
in,
anything? I apologize.
I'm reading it verbatim. The only thing I can tell you is it came in during your ADA session.
During the ADA session. Okay. Can you repeat the question? I apologize, Pat.
What must employers do when they suspect employee performance issues are a result of language barriers?
Okay. Well, that is kind of outside the scope of an ADA and what we cover, but I mean, it's a very good question. If someone thinks there's an issue with the language barriers, they should definitely confer with their employment counsel and talk that through, because this sounds like a very fact-specific situation. And if they think that is the case, then they may want to work with the employee and determine, what they want to do in terms of the performance. But I can't really, we're here to help, absolutely, but we can't really give legal advice on specific situations.
Okay, great, thank you. Last thing, and I want to be respectful of time, just a quick reminder, July 19th at noon Eastern is the DMEC webinar. We're including a coupon code in the presentation deck that I will be sending to all of you that have registered. A couple of times throughout the presentation, the blog was mentioned. Quickly, it is matrix-radar.com. If you're not already a subscriber, I encourage you to subscribe. Signing up for the blog is a two-step process. We're going to push out an email confirming that you do, in fact, want to subscribe and you are who you say you are, and then you can complete registration. Thank you all for your time today. Thank you all of our presenters for your time, and enjoy the rest of your day. Thank you.